everyone. This is Richa Kaur from Manu Law Classes. Today I'm going to be discussing with you the topic of legal maxims and foreign phrases. These maxims, they are mostly Latin terms, so it's very important that we understand their meanings. So let's get started. We have also started a 1 year as well as a 2-year program for all the CLAT aspirants, and you may enroll with us today. We are also providing a 15-day free trial, and you can click on the link in the description below and sign up for it. Let's start with the maxims. The first word is ab initio. So ab means from and initio means beginning. So it means from the beginning or from the start. We can say that a contract was void ab initio, or it was not valid in the eyes of law from the beginning. So, for example, if there's a contract that has been entered into between two persons who are of unsound mind, so such a contract would be void ab initio. It would be invalid from the beginning. Or if there are two people who have not yet attained the marriageable age and they have gotten married, so such a marriage would be void ab initio, or it would not be valid in the eyes of law from the beginning itself. All right. Now let's go to the next term, that is ad hoc. So ad hoc means for a particular purpose or for a specific purpose. For example, the Supreme Court, it constituted an ad hoc committee to study the effects of air pollution on human beings. So here we can say that once the committee has finished the task of the study, the committee would stand dissolved. Or the central government, it constituted an ad hoc investigating committee to investigate the murder of a BJP MLA. So here, once the investigation is over, such an ad hoc committee, once it finishes the task, the specific purpose, the ad hoc committee would cease to exist. Okay? Next, we go to the word amicus curiae. Here, amicus and curiae, there are two words. Amicus means friend or an advisor, and curiae means court. So it means a friend of the court. Generally, an amicus curiae is appointed by the court in order to assist it or in order to give it information on certain questions of law or fact, which the judges are not very conversant with. For example, there's a tax matter or an accounting matter or a banking matter that has come before the judge, before the court, and the judges, they don't have enough knowledge on that particular subject. So they can appoint an amicus curiae who will help them and who will assist them in giving information on that particular case. All right. Now let's go to the next maxim, that is actus reus. So we'll study actus reus and mens rea together because both actus reus and mens rea are very important components of a crime. All right. So actus reus, actus here means act and reus means guilty. So it means a guilty act or a physical act of a crime. For example, the actus reus in case of murder would be unlawfully killing someone or unlawfully murdering someone. So that is the actus reus. If you're using a gun or a knife or anything, so that is actus reus. And mens rea would be, mens is mind and rea is guilty. Guilty mind. So mens rea is the intention behind the crime. So if I have intended to murder you, so that would be mens rea. Both are very important components for any crime to be committed. Okay. Next, we go to the maxim actus reus non facit reum nisi mensit rea. Okay. Here you can see the two maxims that I just explained to you. Actus reus is also there, and then there is mens rea also. So as for this maxim, it means that an act itself does not make a person guilty unless there's a guilty mind or unless there's an intention. So actus reus is not enough. There has to be mens rea as well in order to constitute a crime. For example, I go for hunting and I see something moving behind a bush and I think that it's a rabbit and I shoot. And after some time, I go and I find out that it's not a rabbit, but it was some other person who was hiding behind the bush. So here, though there was actus reus, but I did not have any guilty intention. I did not have an intention to kill somebody, right? So I can protect myself by virtue of this maxim. Next is audi, altrum, partum. Audi means to hear, altrum means other, and partum means party. So it means to hear the other party. This maxim is very important as a principle of natural justice. So when you study administrative law, you will come across this maxim very frequently. This maxim means that before a judge passes any order, it has to give an equal opportunity of being heard to both the parties. It has to give them the right to be heard. And if this principle is violated, the person can claim relief that no, my right to be heard has been violated by virtue of this maxim. Right? Next is bona fide. Bona means good and fide means faith. So it means in good faith. For example, I make a bona fide statement of my intention to sell my property to you. So here, in good faith, I want to sell my property. There is no deception, there is no cheating, and there's no fraud behind my intention. Okay, so then I can say that it is in good faith that I want to sell my property. Or you can say that the text or the content on this particular website is bona fide. That means it is genuine. Okay. Next is caveat emptor. Caveat emptor, this maxim means let the buyer beware. It means that any person who is buying any product from the market or any goods from the market, he has to exercise caution while buying the said product. He has to check for himself if the product meets the quality standards. If वो rotten तो नहीं है, वो खराब तो नहीं है, and later he cannot go to the shopkeeper and tell him कि आपने मुझे ये खराब चीज बेची है. Okay, it is the duty of the buyer to be careful while he is purchasing the product. Next is damnum sine injuria. This maxim is a very important maxim in law of torts. Here, damnum means damages, and sine means without, and injuria means injury. So it means damages without any legal injury, or damages without any violation of your legal right. For example, I have a sweet shop in GK in Delhi, and one of my friends, he opens another sweet shop, and due to him opening another sweet shop, all my profits and my customers have gone to him. So I have suffered a loss, I have suffered damage because he has opened another sweet shop just next to mine. Okay, so here, though I have suffered a damage, but there has been no violation of my legal right. So I cannot go to court and claim any form of relief or any remedy because there has been no violation of my legal right or I have not suffered any legal injury. All right. Okay. Just opposite to this maxim is injuria sine damnum. So injuria means injury, sine means without, and damnum means damages. So this is exactly opposite to the previous maxim. Here, there is a violation of the legal right, but there are no resulting damages. All right. For example, I have a house and you enter upon my house or my property without my permission. I don't like it. I don't want you in my house. So here, I can sue you for the offense of trespass. Here, the act of you entering my house has not caused any damage to me. I have not suffered any loss whatsoever, but my rights have been violated. So I can go to court. I can sue you, right? The next maxim is de facto. De facto means in fact or in reality. Let me give you an illustration. During the time of the Congress rule, the Prime Minister was Dr. Manmohan Singh. But we can say that the de facto power was being exercised by Mrs. Sonia Gandhi. Okay? Or we can say that in Pakistan, it claims to be a democracy being run by the Prime Minister and his cabinet, but the de facto power, the real power, is actually being exercised by the military. Okay. The next maxim is de jure. De jure is opposite to de facto. De jure is by law. Okay, jure word means law, so it means by law. So recently, the Trinamool Congress, it won the elections in Bengal. So here, Mamata Banerjee is exercising her power as a chief minister de jure. So legally, by law. Okay. The next maxim is doli incapax. Doli incapax means incapable of committing a crime. This maxim is generally used for children who are under the 7 years of age, and they can claim protection by virtue of this maxim if they commit a crime. Because the law presumes that a child who is below 7 years of age, he does not have enough or sufficient mental capacity. उसमें इतना दिमाग नहीं है कि वो अपने act के consequences समझ सके. He cannot understand the consequences of his act. If he is doing something wrong, what will be the consequences of that wrong? Okay, so if a 5-year-old boy murders somebody with a gun, so here he will not be held liable for murder. He can claim protection by virtue of this maxim, doli incapax. Okay. Next is de minimis non curat lex. Here the 2 words in the maxim you may relate to. Minimus means minimal and lex means law. So it means law ignores minimal things or insignificant things. Law does not take into account trivial matters or petty matters. For example, somebody just pinches me on the street. So I cannot go to court and sue him and say, oh, he pinched me while I was walking on the street. The court will not take that suit into account. It will dismiss the suit, saying it's a very trivial matter. It's a petty matter. You cannot come to court for such a small matter. Okay. Next is estoppel. Estoppel is a rule which prevents a person from denying what he earlier stated. That means if I make a statement today, I cannot retract from it tomorrow by virtue of the rule of estoppel. Okay. So today, if I'm telling you that I am going to sell you my property for rupees 1 crore, tomorrow I cannot go back on my statement and say, sorry, I will not sell you for 1 crore, but I will sell it to you for 2 crores. So by virtue of rule of estoppel, I am prevented from denying what I earlier stated. Okay. Next term is ex gratia. Ex gratia is as a favor. If somebody does something voluntarily out of kindness, so that is ex gratia. Like the government recently announced an ex gratia amount of rupees 1 lakh for all the COVID affected families. So the government is doing a favor by giving rupees 1 lakh to people who have been affected by COVID. Or you must have heard that when there's any train accident, so the government announces relief measures or it announces ex gratia packages. Okay, so that's where the term ex gratia is used. Next is ex parte. Ex parte is proceeding that is held in the absence of one party. Okay, for example, the judge is passing an order in a divorce case ex parte. So it is not hearing the other part, one party. The one party to the case is present, but the other party is absent. So the order was passed ex parte. Or the bail proceedings in a particular case were conducted ex parte. That means in the absence of one of the parties. Okay. Next term is habeas corpus. Habeas means to present, to produce, and corpus means body. So it means to produce the body. This maxim, it comes into picture when a person is illegally detained by the police or by ABC. So he can go to the court and the court will issue a writ asking the said detaining officer, the police officer, to produce the person whom they have detained before the court. Okay, and they have to show that why have you detained this person and what is the cause of detention. So that is to produce the person before the court. Okay. Next term is prima facie. Prima means first and facie means appearance. So at first appearance or at first sight. For example, if there are two people in a room, one person has a gun, okay, and the other person is shot. So prima facie it appears that the person who had the gun, he was the person who shot. Okay. So at first appearance, at first sight, this is what the case seems to be. Okay. The next maxim is ignorantia juris non excusat. Here the word ignorantia means ignorance, juris means law, non excusat means non excusable. So it means ignorance of law cannot be excused. You cannot say that you did not know that this particular law existed. For example, now that the government has made wearing of masks mandatory in a public place, okay? So tomorrow if a police officer comes and finds you for not wearing a mask, so you cannot defend yourself or protect yourself by saying that, sorry, I was not aware of this law. You ought to know the law. It is your duty to know the law and you cannot claim ignorance, okay? Or let me give you another example. If you've parked your car in a no parking zone, okay, and you are challaned for it, you cannot tell the traffic police that, sorry, I was not aware that this was a no parking zone, all right? So ignorance of law excuses no one. Next term is in lieu of. It means instead of or in place of. For example, the company announces cash bonus for its employees in lieu of their unused vacation leave. So it means in place of their vacation leave, which they did not utilize, the company is paying them cash bonus, right? Or let me take another example, that if I have gone and worked at a bookstore for a few months, and the bookstore, it doesn't pay me money. In lieu of the money, it gives me some novels to read. Okay, so that is in place of, in lieu of. Next term is right in rem. Right in rem means right against the world, where a right is available to you, but this right is available to you against the whole world. For example, if I own a house in Gurgaon, okay, I have a right to enjoy the ownership as well as the possession of this house. And this right is available against the whole world, against every person. It is not only against a specific person, it is against every person. No person can interfere with the enjoyment of this right of mine. No one can come and tell me, sorry, this house belongs to me. Okay, no one can interfere with the enjoyment of this right of mine. Next is right in personam. this maxim right in personam is contradictory to right in rem, exactly opposite. So right in rem is right against the world, but right in personam is only a right available against a specific person. All right. So for example, I have sold my car to you. I decide to sell my car to you for rupees 1 lakh. Okay. So my right in personam is only against you with respect to receiving the money for the car that I have sold. So I can only come and tell you that please pay me the money for the car that I sold to you. This right is only available against you and not against anybody else in the world. All right. So it's a right in personam. And this right in personam is generally available in contractual matters. Next maxim is onus probandi or burden of proof. So the burden of proof or onus probandi, it lies on a person who's disputing something. For example, there's a child that is born out of a wedlock. So it is presumed that the child is a legitimate child. Now here, if anybody is disputing the legitimacy of the child, the burden of proof or the onus probandi lies on him to prove otherwise. Okay? Next is Q facet per alium, facet per se. This maxim is a very important maxim with respect to law of agency, where there's principal-agent relationship or where there's master-servant relationship. It means that he who acts through another is deemed in law to act himself. If I am doing my act through you, being your employer, it will be, if you're doing the act through me, it will be as if the act has been done by me. All right. For example, if I am your master and I have asked you to fix a roof that has been broken of my client, and you fix it, but there is still some leakage that is there. So tomorrow, not only you, but even I will be held responsible to my client because I am liable for the acts that are done by you by virtue of this maxim. All right. Or let me give you another example. I asked my driver to go and drop my friend, and on the way he causes an accident. Okay, and somebody is hurt. So here, not only my driver will be responsible, but even I will be held accountable for the accident that is caused because he has acted under my directions. Okay. The next maxim is respondent superior. This is similar to the maxim that I just explained to you, Q facet per alium, facet per se. Respondent superior means respondent here is responding, and superior means a person who is in authority. So it means a person in authority is responsible. So similarly, for master-servant relationship and for principal-agent relationship, this maxim would be applicable. Okay. Next is quid pro quo. Quid pro quo means something for something, a favor for favor. It's generally used in contract law. It means that if I am selling you some goods and quid pro quo, you are giving me money for as a consideration for the goods that I have sold. So quid pro quo as a favor or something for something. So goods for money. All right. Next is uberima fights. Fights means faith and uberima means utmost good. So it means utmost good faith. Okay. This maxim is generally applicable in insurance contracts where there's a high level of fiduciary relationship that is involved, a relationship of trust that is involved between two parties. For example, if I am taking a health insurance policy, so it is my duty to disclose every material fact relating to my health to the insurance company, because this contract is a contract uberima fight. Between both of us, this contract is of utmost good faith. So I have to disclose every material fact regarding my health. All right. Let's go to the next maxim, ubi jus ibi remedium. Ubi means where, just means right or law, ed means there, and remedium means remedy. So it means where there is a right, there is a remedy. Okay. So here, if the law has granted you certain rights, it has also provided you a remedy in case that right is violated of yours. Okay, because then the granting of rights would lose its significance. If the law has granted you right to equality, so if this right to equality of yours is violated, then there you have another remedy. You can go to court by virtue of filing a writ. You can go to court and say my right to equality has been violated. Okay. Then is vis major. Vis major means act of God or a natural disaster that could not be prevented by any human intervention. By any human, such an accident could not be prevented. For example, if there is floods or there is a cloud burst or there is an earthquake, so these are called vis majors or act of God. So if any accident is caused due to vis major, there is no person who can be held liable. For example, if there is a cloud, like recently in Uttarakhand, there was a cloud burst, and because of this, there was flooding in the entire region. So here, this was an act of God. It was vis major, and nobody can be held responsible for an accident that is caused by way of an act of God. Okay. Next is volenti non fit injuria. This is the last maxim that I'm teaching you. Volenti here means voluntarily. Non-fit injuria means voluntarily suffering any damage. That means if I have given my consent, knowingly and willingly consented to suffer any harm, then later I cannot sue you or I cannot claim any relief if I have suffered any damages. For example, if I am agreeing to sit on your bike and I know that the brakes of the bikes, they are not functioning properly. And after sitting on your bike, I get hurt because of an accident. So here I cannot come and claim relief against you for the damage that has been caused to me because I voluntarily consented to sit on your bike. Okay. Or I can give you another example. If I have gone to a cricket stadium to watch a match, and during the match, the ball hits my head. So here, I cannot claim any damage or any relief for the hurt that has been caused to me because I consented. I consented by just going to the stadium and sitting there and watching the match. Okay, so by virtue of this maxim, I cannot claim any relief. Okay, so students, with this, I conclude my lecture. I hope you enjoyed as much as I enjoyed preparing this topic for you all. Thank you.